Yeah, so I'm Rob Murgis, and I teach at UC Berkeley, and I'm very, very pleased to be here and to moderate this panel. I'm going to introduce the panel members and then just say a couple of things to frame the discussion. And then I'm going to allow each of our speakers to just have a few minutes to talk about the general themes, and then I will try to do my better Mark Lemley impersonation and fire out some questions and try to get everybody stirred up on some of these issues. So you can see from your program that the title of this panel is The Market for Patent Litigation, International and Domestic, but that is just a very rough kind of framing device. We'll try to be more specific as we go along. I'm going to introduce the speakers in the order in which I will ask them to make some comments. So we're going to start with Steve Carlson, and he is down on my far right, so the far left here. Steve's a partner at Fish and Richardson, and he has extensive experience in patent enforcement actions, both on the plaintiff and defendant side, and he has some particularly recent experience with some international enforcement issues, which I think are very au courant these days in a lot of technology industries, as many of you know. To his left is Mallun from RPX, and she has done us the great service of producing some slides to frame her comments. As many of you may know, Mallun's in her prior incarnation was for many years at Cisco. Now you may say, how could she be for many years at Cisco and still be so young? I don't know how that works, but that's how it is. And I think I'm going to draw on that to some extent, because even though now she's at RPX, she does have a wealth of experience on the other side, so to speak, of some of these issues. That is to say, on the side of a big technology producing company. And so I hope that in addition to her current role at RPX, she will, in a virtual sense, jump to the other side of the table at times and provide us with some of her insights from her years at Cisco. Next to her is Chip Lutton, who is currently Vice President and General Counsel at Nest Labs, which is a Silicon Valley startup in the energy sector. They're making a learning thermostat, he tells me. I think in this room we probably could have used a learning thermostat a couple of hours ago. I'm also going to ask Chip to draw on both his current experience as a startup general counsel and his experience, which many of you are familiar with for many years, at Apple Computer. And again, the same comment applies. How could he be so young and have many years of experience? I don't know. Sitting next to him is Matt Powers, who is now with the Tensegrity Law Group. I'm sure he will tell us some things about his current activities, which are mostly on the patent enforcement side, and that's extremely important for the topics we're going to talk about. But I hope Matt will also jump in onto the virtual other side of the table, because for many years he had a lot of experience in patent litigation, representing big producing companies when he was at Weil Gotshal. So I think we have a range of experiences represented on the panel, both in terms of their current positions and also their life experiences. As for me, I have written somewhat on the problem of NPEs or trolls, and so I have studied this issue sort of from an academic point of view. I've also been involved with a startup company that, for the most part, was advising larger companies on acquiring patent portfolios, a company called Ovidian, the Ovidian Group in Berkeley, California. So I, too, have some experience kind of on both sides of the table, although my two sides are kind of academic and then more practical. Okay, so in terms of the topics, if you look at the subject matter that's in the title and you think about the experiences that we bring to this, you might say to yourself, what does this have to do with patent institutions? And of course, many of you, I think, are well aware of the fact that it's the growing secondary market for patents that in many cases is driving some of the most sort of progressive and challenging patent trends. That is to say, the reason that patent litigation is so salient these days is in large part, not exclusively, but in large part, because there's a very active market for acquiring patents, and as part of that market, the ability to assert patents in order to get a licensing program going or in order to form the basis of your whole business model, that's essential to that new sort of world of the secondary market. So there's a very intimate relationship between the growing secondary market and secondary market institutions. And I would count RPX and patent brokerages and lots of valuation firms and all kinds of new startups in this ecosystem. Tensegrity would be in that group as examples of different firms that are populating this new ecosystem, this new infrastructure. The point is that a lot of the, what you might call demand side for litigation is originating with and emanating from this newer sector. And so Peter Manel and Mark Lemley and the organizers of the conference thought that we couldn't really do a thorough job talking about patent institutions today unless we talked about one of the key drivers of this demand side. And that's really what we are about. Without saying too much more, because I don't want to eat up all the good topics. I have been known to do that at times. I wanted to just let each of the panel members say 5 minutes or so, 5 or 8 minutes, on what they think are the major issues in the relationship between the secondary market or the market for patent litigation and the patent institutions, the courts, the ITC, the PTO, that we're really here to talk about. So without further ado, let me start with Steve.
Thank you very much, Rob, and thank you, Peter. Thank you, Mark, for having me here today. So I'd like to address two overall topics from the perspective of the marketplace for patent litigation, from the perspective of the institutions that handle the disputes, one international and one domestic. First, on the international side, we've touched on it already today, but the U.S. is not the only game in town, and we've seen, especially in the smartphone wars and other disputes that spill over beyond the borders, where other countries' systems really have come to the forefront in terms of offering a lot to patentees for getting relief and getting it fast and getting it even better, perhaps, than you can obtain here in the United States. And one country in particular has really shown its own merit as being possibly the best place to go for injunctive relief, and that's Germany. And I'd like to touch some on what makes the German system so unique and so attractive from an enforcement perspective, and what's driving it internally within Germany, within the courts, and within the EU that makes that such an attractive alternative to the United States, or an adjunct to litigation in the United States. One issue there is speed. As Matt mentioned earlier today, the fastest you're going to get district court relief in the U.S. is possibly 2 years, really more 3 or 4 years to get relief in the district courts. Whereas in Germany, you can get your injunction within 8 months. And that's relief that comes very quickly there, and with a fairly high degree of certainty as to what you're getting into there. The cost is much lower. Litigating in Germany might cost you $500,000 as opposed to here in the States where $5 million is easily the entry fee. And there's certain structural issues in Germany that play out really to the distinct advantage of the patentee, which makes it highly attractive for patentees to bring their disputes over there. The biggest characteristic of the system there is the split system. When I heard about this, I was shocked that a country would handle its patent disputes this way, but they split it up, with infringement being tried in one court, on one track, on one timetable, often very fast, and then separately in a different court, on a different schedule, often much slower, you try the validity. And you can easily end up in the situation where you've got a patent found infringed with an injunction coming down well before the prior art's been considered on the validity attack. And I thought it was quite strange. And a lot of people do too, but that's how they do it currently in Germany. And beyond that, many defenses that apply in the United States simply don't apply in Germany. There's no inequitable conduct. The whole business between the patentee, the applicant, and the patent office, that is simply irrelevant in the adjudication on the merits in Germany. Best mode is gone. Really, any inventorship issues are gone. You don't have your witnesses being put up, so if your witnesses, if your inventors are maybe not the best witnesses you want, they simply don't show up in Germany. Another factor that's unique to Germany that we don't have here is there's no early outs for the defendant. There's no motion to dismiss. There's no Markman hearing where you may get a limiting instruction that gets you out on non-infringement. There's no summary judgment. The first day that you show up for court, that's trial. And that's when the defendant may get hit with an injunction. So the pressure on the defendants is enormous in Germany. There's no early outs like we have in the US. Injunctive relief over there, the eBay factors simply don't apply. There's some very limited exceptions once you get the injunction. If they'll enforce the injunction, there have been some limited disputes there where the non-practicing entities won't get the injunction enforced. But all in all, even though it's a smaller country, smaller market than the US, it's a big enough bang. And that if you win in Germany and you get that injunctive relief, that is a huge victory where most defendants can't stand to be knocked out of a market that big. And so for getting global leverage, it's a tremendous advantage to a patentee to bring either their suit or a co-pending suit in Germany. And from an institutional perspective, Germany recognizes this and has done quite well in attracting patent cases to not only to Europe, but to Germany in particular. There's competition between Germany and the other countries for bringing the patent cases in. There's competition within Germany between the different courts. And as we look forward to the future, if it happens, if the Europeans can pull this together, they want to have a unified patent enforcement system that's not country by country, but you'd have one enforcement case across all of Europe. Now, they've got bigger problems there these days than patent litigation, but what you're seeing now is competition among the courts in Germany because there are currently 3 slots for courts in Germany. And one will go to Mannheim, one will go to Dusseldorf, but if there's another court, will get picked for this. So there's competition among the institutions there as to who will be part of this system. And we could talk more about all that. One other aspect I mentioned, I want to touch on something domestic in terms of competition in the enforcement realm here domestically. But it's with the AIA, you're going to have disputes now being brought either in the patent office or in the district courts. With the post-grant review, you're going to have now this competition between the patent office and the district courts and trying to figure out how that interplay will play out going forward. That's going to be very interesting with a very complex dynamics driving whether parties will be attracted to the PTO or to district courts.
Okay, thanks, Steve. Mallun, your turn.
Okay, let's see if I can walk and chew gum and click at the same time
Okay.
since this does not track this or this. Okay, so thank you for putting this amazing event together today. I find it fascinating. Let me start by first providing you with a little background on RPX, because then I'll launch directly into a bunch of data. But many of you may wonder, well, why do you track all this data in so much excruciating detail? You'll see why. So, okay. So what RPX is what's referred to as a defensive patent aggregator. And for those of you who don't know what a defensive patent aggregator is, it's in a nutshell, aggregating resources and pulling together resources from a large number of companies to buy patents before they can fall into the hands of those who would assert them against, whoa, oh, against, against them. So in short, it's buying the patents. Do we want to let it out? In short, it's buying the patents before they can be a problem for companies. So our business model's entirely defensive. We don't assert our patents, and all of our members receive a license to everything that we buy. Okay, so on to some of the data, which is the patent marketplace is one of the least transparent areas for data. So what I'm going to show you today are a lot of graphs and a lot of numbers, but I find that because there's such an utter lack of data out there, people find it very useful. So the supply of available portfolios has increased. From 2010 to 2011, there was a 21% increase. And so the way that we've tracked this is RPX is one of the largest patent buyers out there, and where we sit in the marketplace, we think we see virtually every patent that's transacted, and so we use what we see as a proxy for what's going on in the market. So when you see there is an uptick between 2010 and 2011, with really the second half of 2011 being an increase, and I'll let you guys guess what led to an increased interest in selling and looking to see how to monetize patents. Any guesses? And that was, of course, the Nortel transaction, raised the visibility of patents for everyone. Okay, so let's see, this one is. So the other thing that we track is not only the number of portfolios that are shopped, that are available in the market, but how many are actually transacting, because that's another relevant number. So in 2010, we know of 232 transactions that occurred in the open market, and in 2011, there were 340. So that is a 46% increase. And what we also know is there's a large uptick is actually primarily driven by NPE buying activity. What we also do is track in the PTO database where those patents end up, and then track that with our extensive NPE database to figure out whether they are actually an NPE. And so NPEs have almost doubled their purchase year over year, and approximately 2/3 of the patents that are purchased today are purchased by NPEs. Another thing that's interesting to note is you have a lot of large companies these days who are in the headlines with buying and selling patents. When we actually look at the data in terms of number of transactions, they're actually dominated by smaller companies and smaller transactions. Just the large companies are really big transactions that make the headlines. So the next question that we often get is, where are people buying? Where are the portfolios being shopped? And this is something that's actually fairly consistent quarter after quarter and year after year, which is it's fairly well spread between semiconductors, consumer electronics, PCs, and software and e-commerce tends to be one of the higher areas. And then, of course, so not only do we track what's being marketed, what's being transacted, what type of assets are being transacted, but we also see, okay, now that a patent's being bought and sold, what happens to that patent? As expected, if you're selling a patent and an NPE buys it, you can expect that the patent will be enforced. And so this is a typical timeline of an NPE patent litigation campaign. So this is actually a real campaign with the names obscured so that you can't see. But so these assets were marketed in August of 2009, and they transacted to an NPE a few months later. So that NPE went on to mount an assertion campaign that lasted a little over 6 months. And after this, began a series of litigation over the next year, with each one with about 20 defendants over the next year. And so post-AIA, you would probably see the patent cases being having fewer defendants per case. But this is very typical about what happens post-transaction. So let's switch gears for a moment. Earlier today, Commissioner Aronoff shared some comments during her comments some stats relating to NPEs and patent filings, and as well as noting that for the number of NPE cases, there actually aren't that many in the ITC, so statistically the numbers are not particularly relevant. But what I thought it might be interesting for this group to know and to frame the discussion for this panel is, what are some of the details behind those numbers? Okay. So, in the ITC from 2010 to 2011, there was a 44% increase in all patent cases, investigations that were filed in the ITC. And it's always interesting also to compare and contrast that with the district court. And in the district court, there was a 30% increase in all district court patent filings from 2010 to 2011. Okay, let's see. Okay, and of the 62 patent cases, of the 62 ITC cases filed in 2011, 16 were filed by NPEs. And of the nearly 3,500 patent cases filed in 2011 in district court, a little over 1,300 were filed by NPEs. So what you see here is and I'm glad to say that these percentages match the percentages that Commissioner Aronoff gave earlier, is there's a 26% increase from 2010 to 2011 in patent filings in the ITC, and if you look over the trend over the 2005, in which there were 0, 2006 to 2011 period, there's a 600%. But again, if you look at the total numbers themselves, they're simply not that high. So to get a real accurate picture, okay, wait, so let's see, of what's going on, what we also track is not just number of, oops. Okay, let's see if we're on the right slide. Okay, we don't just track the number of cases or investigations that are being filed, but how many defendants are being affected or respondents are being affected. And so what this shows is how many ITC respondents are there in the different years and how many versus district court defendants. And so in 2011, there were 467 ITC respondents and nearly 9,000 district court defendants. And of course, looking at everything in terms of what percentage are NPEs, you flip to the next slide, which is of the 467 respondents in the ITC, 235 were in NPE cases. So, and of the nearly 9,000 district court cases, about 5,600 were in NPE cases. And then we're getting to the end here, which is, so if you look at the percentages, you've got nearly 50% of the cases, nearly 50% of the respondents in ITC cases were respondents in NPE cases were in NPE cases, and about 57% in district court cases. And then the final slide is also another trend that's interesting to note. One of the most, I think, effective provisions of the AIA in having an immediate impact is the Joinder provision in terms of the number of defendants allowed per case. So you'll see that in 2011, the number of defendants, average defendants per case, did decrease, but with respect to ITC investigations, the number actually increased. So with that, I will turn it over to Chip Lutton.
Very nice. Right on time. Okay, Chip, you're up.
Thanks. So certainly one of the most prominent aspect of the last 10 years of practice has been this emergence of a secondary market in patents, and Mallun focused on the role of that in fueling NPE litigation. But the secondary market fuels a whole range of other patent activities. And one of the things I had started to realize over the last several years and towards the end of my time at Apple is that really everything that an IP manager in a corporation is charged with focusing on and doing and architecting in terms of the IP business of the company can be addressed through some emerging tool in the secondary market. So if you think about the core function of building a patent portfolio, acquisitions, companies now are routinely turning to the secondary market. It's no longer the case that you have to wait and build a portfolio over many years. You can have immediate relevance in a market. Defense, you've got emerging entities like RPX and AST and others that are very active in the secondary market. If you want to if a company wants to focus on just the old business of using IP against a competitor but doesn't want to do that in its own name, there have been what have been called privateers, but basically third parties that are available to acquire and assert IP against someone. So all of these things that companies have historically dealt with and wanted to focus on from an IP point of view are now being addressed with new techniques that come out of the secondary market. The interesting, and I think that's really good. I think it's actually an incredible opportunity and really means that IP is more important and more accessible to a broader range of companies for a broader range of uses than it has been historically. But the interesting thing about it, thinking about the system as a whole, is that we still put an enormous amount of focus on the litigation system, and the litigation system is still a very inefficient system for really getting to core values in IP. What is the real value of this IP? And it's a very high transaction cost system, very difficult to discern valuation. In almost every case, it involves years of work and millions of dollars of expense to figure out what a single patent or a small handful of patents are worth. So, you know, in a way, I've come to think of, you know, the issue of how do you unlock some of the potential and the value in the IP system from being dependent so much on the litigation system, and is there some way that you can make the litigation system work better to address some of these needs for valuation? And so I have just a couple of thoughts. One is the insight that the litigation system really approaches, we've just gotten used to all the model rules all around the country, and by and large, of course, from the point of view of any single litigation, it makes the litigation proceed very in a very streamlined way. But it does fall into a little bit of a trap of kind of treating litigations in a one-size-fits-all model. And this is not to be negative or critical, but one of the downsides of patent litigation model rules is that they kind of assume that all cases will unfold in a certain way and have a certain goal at the end. And if you think about the range of business purposes being carried out by patent litigation, I think that assumption bears further consideration. And so looking at ways in the patent litigation system to take account of what really is at stake in this dispute, and potentially flipping the order of issues, potentially finding a range of ways to adjust the litigation system to take account of that, I think is one really good challenge. The other is something that's been talked about a great deal today, but relying on the PTO expertise to assess validity, and not doing so begrudgingly, but really embracing that and making sure that the litigation system is prepared to take account of the timing and the data needed to make the re-examine or the review process work. I think it's it allows the cost to come out of the system and allows IP to be used in a way that isn't, again, sort of handcuffed by the extreme cost of litigation, and doesn't assume that the only way to inject IP into a business issue is through the litigation system. So those are my kind of high-level comments, and I think we'll probably talk about both of them more.
Okay, Matt.
Well, the thought I wanted to throw out just for a thought exercise is to build on what some people have already been talking about, which is what I think of as the economic maturation of patents as an asset class, and build from that into an ideological maturation about patents as an asset class. If you go back 15, 20, 25 years ago, patents, both in their economic terms and in the ideological terms, were really formed, built, decided, driven by large companies acquiring them in pretty mindless ways. They were not really used very much. They were acquired because that's what people did. That it was more of a Benny given to an inventor than it was really something that companies built, acquired, used in any tactical or strategic sense at all. And as an asset class, because they are assets, just like any other asset, they were absurdly underutilized. I mean, ridiculously, absurdly underutilized, and ridiculously, absurdly obtained, thought about, valued, and they sat there, and they sat there, and they sat there, and life abhors a vacuum. So ultimately, people started thinking about that asset, and like a lot of other assets, it has gradually, slowly, begun to mature as an asset class so that you get a pretty robust range of business models being employed and a pretty robust range of disciplines coming in to think about it. You have financial expertise being brought to bear on patents as an asset class that hadn't been thought of 5, 10 years ago. 5, 10 years ago, you wouldn't have a panel called the market for patents and patent litigation. The whole concept would have been foreign. But now you have financial instruments being thought about. You have players who were very, very deep into the traditional defense side, large company side, like Mallun, like Peter Detkin, like others, going into embracing very different business models and how you think about patents. When you look at what Intellectual Ventures is doing, what RPX is doing, what ICAP is doing, there's 20 different business models, and some will be successful, some won't. But, and what has not happened is that our collective ideological maturation has not kept pace with the gradual but accelerating economic maturation about patents. And the ideological perspective is still driven by, sort of built by what we all embraced 20 or 30 years ago, me included, which is you think of them defensively. And once you start to think about them as an asset in a way that traditional mature asset classes are, you think about that differently. You bring to bear different expertise. You bring a lot of people who used to think about it differently and are now embracing how you will value those assets, how you bring them to bear. And we're early in the economic maturation process, but we are nascent earlier in the ideological views of it. And when you listen to some of the comments today from people who are very, very smart in embracing what they're doing, there is to my mind at least, still nascent view about the value of enforcing a patent based on who the enforcer is. And once you start to embrace them as assets that are economically driven, as many others are, we will, I think, begin to think differently, or think different, about how one might treat people who are enforcing patents and whether they should be treated differently, whether it's an individual inventor with which America seems to have a great affection, or the company to which that individual inventor sold the patent so that that individual inventor could get some relief from it. And there were many, many, many individual inventors who sat there collecting patents in their drawers and got nothing for them. And we lauded and heralded them, but did not pay them. And that, at the end of the day, is probably not a sustainable business model, and that's where a lot of this is going. And I think it's time to embrace your inner troll, and not to scorn your inner troll. And the last comment on that is, I would say trollness is as trollness does. The issue isn't who's enforcing a patent. The issue is the quality of the claim. The issue is the quality of the claim. Large, established, respectable companies bring really lousy patent claims against their competitors, sometimes because they have to. They're terrible claims. No one scorns them for doing that. And an NPE can bring in a really valuable claim with a really valuable patent. And yet, somehow, that's a subject of scorn. I think that's where the ideological maturation process needs to evolve.
Okay, so here's a little thought experiment, okay? So you were out walking the dog and you met with an unfortunate accident. There was a bus coming that you didn't see, and before you realize it, there you are, panelists, at the pearly gates, the much discuss pearly gates, right? And St. Peter's going through the list, and he's saying, okay, there was how you treated your kids and how you treated your parents and how you treated your spouse. So you get through all the stuff you expected. Then you get a question you did not expect. And that question is, what's your best evidence that NPE activity added to research and development or innovation? What's your best evidence? So how do you answer? Now remember the context, right? You can't spin this guy, okay? This has got to come from your heart, from your gut. What's your best evidence? When you're lying awake at night at 4 a.m., asking yourself, should I jump to fill-in-the-blank enforcement entity from my fill-in-the-blank established entity? What did you decide, inside your own heart? What made you make the jump? And this is what you got to tell them. So,
I think that puts the burden of proof in the wrong place. I'd reframe the question as, what's your best evidence either way about whether they do or don't? That imposes a burden of proof that I don't think is appropriate.
okay, I guess that's an answer, sort of. Anybody else? That is wishy-washy. Go ahead. Anybody else?
So is the question pretending that we're an NPE and trying to justify how we've added to innovation?
Yeah. So the question is, what's the best evidence that this activity supports the basic, the reason that we're all here, at least in theory, which is to encourage R&D and innovation. What's the best evidence? Mallun, do you have any, or are you strictly going to say, we were just playing defense, we didn't invent the problem, we didn't invent fires, we just were selling fire insurance?
Well, first I was going to have either Pete or Matt answer. So what RPX is it's true. The RPX business model, which is to serve as a defensive patent aggregator, which is to buy up the patents before they can fall into the hands of NPEs. So one could say that if NPEs didn't exist, RPX wouldn't exist. And so, what St. Peter would say to that, I don't know. But what I do say is that, there's a few points that Matt made that I do agree with, which is that, patents for a long time were not recognized as an asset class. It was you filed them primarily to have an arsenal in case someone came to attack you, but now they're actually viewed a little bit more proactively, or a lot more proactively. And so, but I would still say that, and so I guess NPEs went a long way toward having the recognition that patents are an asset that are worth value. Again, going back to whether that's good or bad, still up in the air. But I still find it, I guess the evolution may be helpful in that, okay, I'll come up with this. This is not a question that he told us in advance that we were getting, by the way.
That was the whole point.
But I guess in this way, to the extent that it helps patents, which have value, I think indisputably have value, and that people start to recognize that it is a tradable asset that has value, then you start to get away from saying, hey, I have a patent assertion, or I have a letter from an NPE, or if someone's trying to sell me a patent, that the first thing you do is to go to the courts or to file a lawsuit, because that's certainly not the most efficient way of determining the value. So if NPE sort of helped trigger the evolution of patents into an asset class so that patents were actually freely tradable, and perhaps then you became more comfortable reading patents and maybe going back to the fundamental basics of what a patent is, promoting innovation, then perhaps that would be helpful. Now, depending on when I die, that may or may not actually happen, so my answer may change on that.
Okay. Let me embrace my inner troll here. I work with a lot of sole inventors, and there's something that drives them that says, I want to build the next thing and I want to get a patent. And it's something that the two are somehow intertwined. When these guys are in the garage, literally often in the garage, they want to not only make the next whatever it is, but they also want the patent. But as Matt says, these guys aren't good at enforcing patents. There's huge transaction costs in terms of making that all go. And the people that are in the garage chipping away aren't the ones that are going to be able to enforce these new inventions on the national scale, on the international scale, whatever it may be. But there is a need, I think, at the right points for groups to step in and help the enforcement of these patents.
Okay, so that's an answer that I think, takes on the question head on and just says there are people with a comparative advantage in enforcement, and there are people who are with a comparative advantage in being creative, and this is a traditional story that we see, specialization, division of labor, and that would support Matt's argument that, the asset class is becoming, more developed and more sophisticated, and that's encouraging a finer division of labor, and, Adam Smith somewhere is saying, good job, way to go. And that's, I think that answer is good.
I think that is the answer. I mean, the answer is that for many things in our economy and our lives, we assume that the result of an efficiently functioning market is positive. And you can easily make the argument that NPEs are a big part of what is making this market operate much more efficiently. And if that creates value and incentivizes value, then the way you get to play in that market is by inventing something.
That's a perfectly good point. I think that's probably becoming maybe the sort of conventional defense. And I don't really have a critique for it, but I would make an observation, which I have written about in some of my work, which is not all markets, the existence of a market doesn't necessarily mean that the transaction is a good thing, right? I mean, we outlaw certain types of transactions because we say a market in that area is not a good idea. So I think it's a perfectly reasonable point, but it in some sense begs the question of, is this a market we want to encourage? However, let me put that aside, because we can go on forever. Well, maybe we're going to. Go ahead.
Well, I just wanted to jump in on two other aspects of a market, which one of which is, markets tend to sometimes tip into bubbles, and sometimes you have pricing bubbles, and you can't tell the difference between the really good stuff and the really bad stuff, and all of it sort of inflates together. And I think that that's one danger. The other is, as we've seen with the financial issues lately, in a lot of markets, there's one class of sort of inside service providers that get really wealthy while, sort of singing how important it is for the rights holder. What they're really doing is kind of pumping money in that they profit from primarily. And so we have to be careful when we talk about these things that we really are serving the small inventor, and that we really are accurately pricing things and not just creating more problem through the process.
Mallun, did you have something else?
One of the things that Matt said was, I believe you said, Matt, was that NPEs are making patent transactions more efficient.
The market more efficient.
The market more efficient. So I would disagree with that. I think that maybe ultimately, when you're further down the road and the market is more developed, perhaps it becomes more efficient, and perhaps the NPEs, I guess, are a necessary evil toward getting there. But I would say the way that the market transacts today with respect to NPEs enforcing patents is incredibly inefficient, right? How many other markets do you go to where you get the letter, you get the patent, you get the assertion, you call your, no offense to those in the room, your $1,000 an hour outside counsel and figure out, okay, how do we litigate? Now, you may say, well, therein lies the problem, which is if there was more recognition of the patents as a class. But today, it is incredibly inefficient. We have an example. One of the things that RPX has the benefit of is we sit in the middle of, over 100 different client companies, from really, really big companies to tiny little startups. And so we get a lot of information about the market and what's going on. One of our clients actually gave us showed us this pitch from an NPE. And I looked at it, and I thought it was just fascinating, because here's what the pitch was, which was this company was, they had about $200 million worth of revenue a year and maybe 80 patents. This NPE proactively came to them, as companies are seeing more and more these days, saying, I want these 20 patents. And here's the value proposition for these 20 patents. I'm going to take these 20 patents. They were in the VoIP space. And I'm not going to pay you anything up front, or maybe I think it was a very small payment up front. It was de minimis. But here's what's going to happen. Here's the length of my assertion campaign. I'm going to take those patents and I'm going to assert them against 40 companies. I think that after I assert them after 40 companies, I'll ultimately sue 20. After I sue these 20 companies, I think that ultimately we're going to collect $40 million in the aggregate. So of this 40 million, there was actually a bar graph that said this, 20%, 15% is going to go to me, the NPE, 25% to 30%, depending on when the case resolves, is going to go to the outside counsel contingency fee, and then another chunk is going to go to the costs and expenses. So of the $40 million, how much do you think was going to go to the company itself for actually compensation for the patents? It was $8 million. So when you look at 8 million versus 40, that's incredibly inefficient. And in fact, if you could have just actually licensed the patents for a collective $8 million, you probably could have avoided that litigation. But the system is such that there's so much uncertainty and there's a lot of lack of transparency as to the value of patents that it becomes very difficult. And then the last thing to add to that is, if you also add in on top of that the defense outside counsel costs, say it was $500,000 a pop because, say, the case is resolved earlier, that would be $60 million of costs to get $8 million to the inventor company. So I would say that's incredibly inefficient. And that is, I think, one of the problems today and why companies end up having to litigate.
It's a good point, but the NPEs would like a much more efficient process. The ones who created the inefficient process are the ones who are charging $1,000 an hour and would like to charge as many hours as they can. The NPE would say, let's get it done in 3 months.
So there are the demands, and and we all know that NPE demands are all over the board. Some decide to ask for a very low number, far less than the cost of defense, just to get early settlements. But you also have a lot of the NPEs who feel like they need to ask for X, because ultimately, through the litigation process, it's going to go down to Y. So, therein lies the problem. It is a very inefficient market, and I guess the result of it is lots of very few people making a lot of money.
Okay, so without getting too, any of these questions, they're all interesting questions, and I think, a lot of the people on this panel are living this every day, so it's really close to the bone. But let me ask a related question, which is maybe, more directly related to the institutional topic that we're trying to center on here, which is, I found that Mallun's figures were really interesting, and 5,600 case defendants, she was saying, are in NPE suits out of a total of 9,000 case defendants. And you have to realize many of those defendants are overlapping. If we took Google out of that, it might be 13 and 7 or something. The Google, Intel, and Apple, right? But the point is, the purpose of this panel was to some extent to talk about the relationship between secondary market and the demands on patent institutions, and that 5,600 out of 9,000 figure captures it perfectly. So here's the question. Are the NPE players, that is to say the NPEs themselves, the defendants, and the aggregation companies that are trying to deal with the NPE problem, are they bearing an appropriate amount of the cost of NPE activity? In other words, if we have a big congestion in the system, and NPEs are a large reason for that, are we paying the appropriate amount, or is there something about the structure of district court litigation which leads to more use of it than is efficient or rational?
Well, I'll take that a little bit because it somewhat goes back to my one-size-fits-all critique that, you take a typical NPE case, and it's very simple in a lot of ways. If you kind of know something about the patent and you know something about the accused product, there's no reason why that case needs to take 3 years and involve hundreds of thousands of pages of discovery and fact depositions going back 10 years. And, I don't want to be overgeneral about it, but I think we overinvest as a rule in those cases. And I think partly we do so because, again, the system assumes that a patent case unfolds in a certain way and that there is relevant data or discovery potentially hiding in a lot of places. But things like the new model e-discovery rule that came out of the Federal Circuit and that's been picked up in a number of courts already, start to, I think, make the proper sorts of decisions scaling back potentially on the overuse of discovery and other things that really take up way too much cost in the overall system compared to what's really needed, especially for a simple case, NPE case.
Okay, related question, which is going to take that as a partial, suggestion that maybe the cost structure is a little bit out of whack. I'm particularly interested in what Matt might have to say about this. Matt, what about the British rule for patent cases or some subset of patent cases? And for those of you who don't know, the British rule isn't, I don't mean bow when the Queen comes in the room. I mean the loser pays the attorney's fees of the winning party.
I'm all in favor of it. I think it's a great idea. I think we should do it.
Okay.
I think that
So when you said that you thought, if a troll puts up an A+ quality patent, you think that the system should give that, full faith and credit, really enforce that to the max. You're willing to put your money where your mouth is, literally.
and pay their fees when they win.
Yep, okay, so symmetrical British rule, and you'd be down
I'm all
with that.
for it. That's why my point is it's all about the quality of the claim. There's obviously, look, no one's here to defend scuzzy trolls. There are people who bring lousy claims.
Yep.
And settle for the less than the cost of defense, and it's impossible, I think, to make a spirited defense of their contribution to the American legal or economic system. But, just as Chip says with litigation, one size doesn't fit all. There's a lot of very sophisticated parties out there bringing very, very good claims who vet the hell out of them, and there's a large number of people who do that. Those people are bringing claims that I think in most cases they would support the British rule. I think it'd be a great thing. It would increase the returns for those who are bringing good claims, either way.
And that's exactly what you're seeing in Germany, where you do see NPE claims. Not nearly as many, though, as in the United States. And there you've got a loser pays system, and you've also got much lower costs to litigate. So the fear factor of the cost of it is really not there. And when it's a lousy patent, it won't be brought. But you do see the claims brought when they're meritorious.
So one argument in favor of some of the new post-grant review procedures in the AIA was that we would be borrowing a page from the efficient Europeans, and I shudder to say that in the current setting, but in the patent litigation context, the idea was maybe if we had a cheaper and yet still fairly reliable alternative, and I see Stu Graham squinting like an economist saying, yeah, that's the right way to phrase it, fairly reliable alternative. If we had a cheaper alternative to district court litigation, would that help solve the problem? Could we channel or funnel some or many patent cases into an administrative procedure which is cheaper and gets us a resolution hopefully quicker, and therefore take some of that cost pressure off the full-bore, gold-plated district court litigation model? Any early guesses as to whether any of the post-grant procedures in the AIA are going to take any of the pressure off this for anybody who's involved in this stuff?
A lot of people are very nervous about estoppel, and not only estoppel on the filer, but also on the privies. And what does that mean? And do you really want to put all your eggs in that basket when you don't have the full discovery, when you don't have the long timeline? You don't have all the compulsory processing to make your case. A lot of people I'm talking to say they don't want to go that way. They want instead to make their challenge in the district court.
So that's still the conventional wisdom despite all the AIA agitation, huh? Anybody got a different perspective on that? Is anybody willing to roll the dice on a PGR to at least try it out?
Well, I think it's going to be helpful. I think the changes as a result of AIA are going to be helpful in the long run. While it was unfolding, I couldn't help but feel like Congress sort of thought this was a good idea, but not really. So they kind of tied a hand behind the back of some of the process, and so it's a little disappointing that it wasn't more openly and readily available. But I think by and large the processes that have been set up are going to be good and effective, and they're going to lawyers will find ways to use that facility, primarily because, at least in my opinion, it's what should happen. The PTO is expert in exactly this issue, the examination of patents, and there's just a lot of undeniable benefit to being able to go back and have a pronouncement, a more careful pronouncement in the small set of cases where it actually matters, as opposed to the first grant. And so given that dynamic, I think it's just going to be a matter of time until that process really takes off. Inter-parties re-exam took off in the years before, and I think inter-parties review and post-grant review will too.
I think there's a lot of truth to that, and I think that I personally have a lot of confidence in Director Koppas's ability to make that work based on everything he's done so far. I guess the thing that bothers me is that what we're focusing on the individual constituent elements of the system, but we're not focusing on how the system as a whole resolves these questions. And it's one thing to say, okay, let's get that post-grant review period to a high quality within a year, and then it'll go to the federal circuit, and it was already 4 or 5 years to come out of the patent office in the first instance, and the district court case is going to get stayed because it's such a great system now and it's only a year. So now you've got 4, 5, or 6 years to get the patent in the first instance, but that's not good enough, because so we're going to make the patent holder wait 4 years to enforce the case until the patent office does a second pass. And it might be more than that, because now you're going to have to go through federal circuit review of what happens in the post-grant review, perhaps. So now you've got a 10-year period between the time that somebody actually invents something and the system has decided it's comfortable letting them enforce it. And I think that's too long. That's just too far. And that should prompt us to think about integrating all of those pieces in a way that shortens that period in a meaningful way. In an odd way, the German system does that, right? Because you get a definitive validity judgment in parallel going with the infringement decision. You don't have a partial validity decision, which then goes back to the district court for a decision on other validity questions that weren't considered in post-grant review. And that whole 10-year period is the period we should be focusing on, not the 1-year period here and the 2-year period here and the 2-year period here. And adding additional 1 or 2 year periods doesn't seem like the right focus overall to me.
Well, that's maybe a good lead into what I think would be the last question before we take some questions from the audience, which is, you know, the secondary market is a relatively young phenomenon, as you can see from the youth of our panel here. I mean, this is young people's stuff. And so I wonder what's next. I mean, we think of maybe the AIA as the end of a big patent reform chapter, but the things that Matt was just saying suggest that maybe it's just the beginning of a rolling process where we learn to adapt to a more a kind of thicker secondary market and all of the institutional demands that causes. So what do you folks see as sort of the next either pressure points for change or reform in the system, or adaptations in the private sector to the institutions that we have? Well, what's coming down the pike here?
I'll take it, since in part I was saying I think stuff out, as part of this evolution, the use and valuation of IP ought to come out of the litigation system and go into more of these market mechanisms. I think better market processes for not only buying and selling, but also trading IP rights are absolutely, you know, kind of the next big step in the evolution in terms of the ability to have a way of interchanging IP the way that companies currently do bilateral IP licensing deals, but to have more of a fabric, a licensing fabric that you can contribute with money, you can contribute with IP, you can take IP benefits out, kind of the way the copyright, an ASCAP BMI collective licensing kind of model works. I definitely think that's something that, you know, there are a couple of offerings or, you know, firms that believe they have an answer in that space, but leaving aside the specifics.
Intended consequences on the litigation side. I mean, one of the things that you can, if you step back and you look at the substantive patent law in the last 5 to 10 years, it's plausible to link some of the changes that have occurred in the last 5 to 10 years to the change in litigation that has occurred as a result of the presence of different parties. When the parties were both 20 years ago large companies fighting it out over market share who had symmetrical interests in the patent system, you had a set of rules that was followed. When you had asymmetrical interests being litigated where you had a patent holder that didn't have that sort of a business, you started to see things being taken away from the jury. You started seeing constraints on DOE. You saw a variety of things that were designed to cabin the threat to the established interests who previously had dominated the space. And I think we're going to see continued evolution in both of those spheres that will be interesting to watch.
Okay. Ron Laurie, what question do you have for us?
Well, Rob, you didn't get a real satisfying answer to your St. Peter's question.
I did just hit him with it totally cold, I have to say.
To the extent you got answers, the answers were framed in terms of reward to the inventor. Whereas what you were really asking is where's the incentive for innovation? Now, reward to the inventor is indirectly related to incentive to innovation, but it's not the same thing at all. In fact, one of the key things is that invention and innovation are not the same thing at all. Innovation takes a tremendous amount of additional resources to get to than invention does. And so the question is, what is the relationship in terms of incentivizing innovation and the patent marketplace? And I don't think there's very much data. There's the Berkeley study, there's an OECD study, but I think we need a lot more data on the feedback loop. To what extent is the monetization market, which I'm a part of, incentivizing innovation? Because that's the policy issue. In that regard, I just wanted to reply to something Mallun said about $8 million out of $40 million is not very efficient. And my answer is, compared to what? What's the alternative to that inventor? Is it to just walk up to a large company and say, please write a check for $8 million? That's not going to happen. So without some incentive, again, unfortunately, and this gets directly to Chip's point about efficient marketplace mechanisms, but right now there is no alternative to litigation. And so things like IPXI and exchanges, I think that's got to be the answer.
Okay, I think Stu is next, and then one more. Okay, go ahead.
Sure. Thanks for the panel. Very, very informative, very thoughtful. I'm at the USPTO now. We're thinking a lot about the information that we have or could potentially provide to make the markets that Chip talked about, the ex-ante markets, the way in which the transactional licensing markets around patents and trademarks, for that matter, work. The presentation with the data was very helpful, but of course that's data in your hands, and I'm sure you're making people aware of it. But to the extent that all of these markets work in an information environment, in a transparent information environment, and we talked a little bit about the types of information that might be useful this morning to judges to be able to better make decisions about their job. What kind of information that's uniquely in the hands of the Patent Office would be helpful to the marketplace for making the kind of efficient transactions happen early so that the system doesn't have to resort to the kind of late decision making that takes place oftentimes inefficiently in the courts?
Yeah, Chip.
I have a couple of nominations for that. One is collection and publication of data about litigation. Of course, it's collected in individual files, but to be able to sort of assimilate that and maybe even break it down along industry or certainly art units. Two, and this is more of a wish list than a reality now, but licensing information to the extent that it can be eventually made part of the public record of the patent, that a patent is licensed, to whom it's licensed, maybe even for what price it's licensed. That kind of information is utterly missing right now, and a key ingredient for an ultimately transparent and efficient market. Three, this is, I think, maybe just loosely in the category of kind of economics data. You know, how do patents correspond to industry? How many patents are there in a particular product class? It's not an easy thing to derive just from the art class units to get to, you know, the right slice that really corresponds to what's going on in industry, but the PTO is probably in the best position to figure out how to assimilate that data and really make heads or tails of it from an economic point of view. And it would be so incredibly valuable to have an authoritative source of information about, in this industry, there are 200,000 issued patents, and they span these categories, and they you know, something about the density, and then contrast that with other industries where it's so very different. That kind of information, potentially information about, you know, about other economic kind of information about the use of patents in trade, in commerce. I know it's not classically, you know, sort of exactly the kind of information that exists in the file wrapper today, but I really think the PTO, as the expert body in this space, is so well positioned to kind of assemble that and pull it together, and it's almost an impossible task for anyone else to do. So those would be my nominations.
So I wanted to comment on Ron Laurie's comments, which is one, I did use the word innovation in that ultimately, if you could get to a market-based solution, as Chip mentioned, where you knew what it cost to license a patent and you could freely license it, then perhaps that could get to the point of back to what the Patent Office was meant to do, which is I'm going to read patents, I'm going to see what's out there, and I'm going to see if I can improve upon it, because if I do, I know exactly what it's going to cost me to develop a business on it. There's no incentive to do that. So ultimately, maybe, you know, 10 ticks down the road, perhaps that's what the answer is. And the other thing is, you mentioned there's no alternative right now. Yes, the most common way of enforcing a patent is through litigation, because NPEs and or individual inventors and others often feel like they have no other choice. But in some ways, you know, when I was at Cisco, we looked at every request that came in, and frankly, there were reasonable requests with reasonable demands, and where we got to a resolution without there being any litigation. Now, when the law is uncertain and is in flux, and there's obviously been a lot of progress in the damages area, and they asked for, someone once tried to sell me a patent for $500 million, one single patent. And he was serious. And another NPE once asked us for, quote, this is a direct quote, $1 gazillion. Now, when you have those requests, of course you're going to litigate. But you can get to the point where if you are making more reasonable demands and your patents are legitimate, to Matt's point, then there are transactions, and I think you'll find companies more willing to actually proactively look at license and proactively license. And the other alternative is what we see, because where RPX sits, is that we're not a litigant, right? We're trying to get to a resolution, which means our clients are operating companies, but in some ways you can think of our NPEs as our suppliers, right, of sorts, which is we sit in the middle. So oftentimes what we're able to do is cut through a lot of the litigation posturing, which has to go on because of the nature of what happens when you're in litigation, and to get to a real number earlier. So I would say there are some alternatives to flat out litigation. It's not as bad as it seems.
It also depends, though, on,
Yes, speaking of clearing, I've got to clear this podium soon. So, Julie, you get the last question.
Okay, I will be quick. First of all, I just have to say that I feel, and I'm not an economist, but I feel a little uncomfortable talking about all of these efficient markets when we're talking about a government-granted monopoly. I just think there's some disconnect there. But I work at EFF, and we do a lot of work on behalf of the defendants and the folks on the other sides of these cases. And to build on what Chip was talking about, one size fits all, when we're talking about litigation, I think It does not make sense anymore to have a one-size-fits-all patent system when you start talking about software patents, because I think the most harm when this system goes awry is felt when we start talking about software. I think it's time to have, a Hatch-Waxman moment, if you will, for software. I'd be interested to hear anyone else's comments on this, but I think we need some carve-outs. It's a system that doesn't make sense. We haven't really been able to talk much today about the folks who don't play at the patent system, who don't file patents, who don't file lawsuits, who don't buy patents, but are affected by it every day. And it's really important that we talk about how to protect those people's interests as well.
That's an excellent question, I think, to end on, and it's nice to give EFF the last word on this topic. I just want to have everybody thank the panel for a great job. Thank you.